My name is John Tucker. So I'm the director of PW Thomas Tucker. That's nice to look at. And the presenter will be Daniel Idina. There's another director of PW Thomas Tucker. So we'll bounce around between us. I look at the attendance list and can see that we've got a fair mixture. So something between very expertise to people who got this thing called the Discretionary trust one we got heard before that. So I was just amble around and finally time questions. So you're really interested in, you might talk about it. We've mentioned tips and traps with discretionary trust, so I thought I might start with the traps, and then we can give some tips about the traps. So, and this is really based on things that we've seen arise in the course of practice. We started doing discretionary trusts, or at least maybe I did, back in the early 1970s. At that time, we had a rule against perpetuities, which restricted the life of the trust to a life then in being plus 21 years. So you'll see a lot of the old trust deeds have this lifetime restriction. That restriction doesn't very daunting back then, but amusingly, we've been looking at some of them more recently, and if you have a look at the royal lives and see who was around in the early 70s, you run across Charles Armstrong Jones, otherwise known as Viscount Lindley, who was born 1 July 1999. After that, you come from ones that were born in so when you look at their lifetime and you add 21 years and you look at now a lot of these trusts running into a third generation, that restriction is well within the purview of the grandchildren's lifetime. And you don't want the trust to run out and then, because the trust has tended to be cut through generations, and in doing so, not crystallise the capital gains tax event by being invested into beneficiaries. So, ultimately in South Australia, the rule against perpetuities has been abolished. So it's up to amend your trustee to remove this restriction. That's not the case in every other state, and if there's property in the other states, the rule can still constrain the life of the trust, that property. But from assets that are combined with CGT assets that are South Australia, you can make this amendment. And there's some merit in doing sooner rather than later. Why did I say that? Well, there used to be there was a well-respected doctrine talking about not interfering with the substratum of the trust, so that even if you had a power of amendment, there was an implied restriction on the power of amendment that you couldn't go so far as to destroy the substratum trust. For example, amend to remove all the existing beneficiaries in A family to insert all the beneficiaries in B family. So while that might be for a variety of other reasons as well, it's a difficult amendment to make. The fundamental thing is this doctrine that you couldn't deal with the substratum. That hasn't really been much respected in terms of modern amendments, and indeed the Commissioner of Taxation is the most important current player in all of this, has issued a ruling which is tax determination 212/21, under which he says that in most cases, provided the trustee validly exercises an existing power of amendment under a trustee, or the deeds amended with the approval of the court, CGT events won't occur. So the Commission has been quite accommodating in regard to amendments. Obviously, he's more interested in amendments than ones that just change the rule against perpetuities. He's interested in the kind of amendment that I mentioned, where A floats out, B floats in, parts of A removed, parts of A are removed, and might happen for a variety of reasons, and perhaps others are introduced. On that rule against perpetuities, there was a corollary provision that inserted commonly inserted in trust deeds, motivated by the same rule that there was a restriction on distributing from a trust with vesting date on the rule, set by rule, to another one which had a vesting day that was later than that which was prescribed by the rule. So, and it's not uncommon for people to have a series of trusts. I think land tax aggregation motivated people to have properties in different trusts, one after another. But of course, if you have trust A for the rule against perpetuities, because you established this in 1977, and then you established one in 1987, with exactly its life. That restrictive rule that I mentioned wouldn't allow you the chance to vest what income out of the first trust, which is say profitable, the second trust, which is year to year. So there's a need to get rid of that restriction as well if it's existing in trust deeds. Another thing that's been really struck quite commonly is restrictions in the definition of beneficiaries. Older trustees talked about the John Smith Family Trust, with its beneficiaries being John Smith, John's spouse, John's children, so on. And it was as time's gone by now, John's spouse may not be living anymore, or John may not be living anymore. And if John's not living anymore, then John's spouse is his spouse. And again, that's a real issue. You can then introduce widower or widow in place of spouse. Well, if the power to add beneficiaries, you probably can, or if the the power of amendment might accommodate that. But a lot of the trouble with this sort of thing is that I think it's covered the problem after the event, after the need to have known about it. So it's desirable to go trust deeds, particularly the older ones, sooner rather than later with these sorts of problems in mind. Another, a lot of the older trustees had a power of amendment which required the consent to settle. So you could have a generous power of amendment, subject to having the consent of the settlor, and in many, many, many cases, the settlor is no longer living. And I mean, there's some variations on that. The power point, essentially point to all primates. But so then, if the settlor is no longer living, and you amend the power of amendment to not require the consent of the settlor, well, the problem is by that time the need for the settlor's consent's entrenched, and you can't really amend the power of amendment, so it's just going to disappear. Looking at the there's been quite some forensic analysis of exactly what they will allow. So it's not just a walk up to assume that you're going to be able to exercise power of amendment successfully. I was looking at this material and noticed that on our website there's a discretionary trust that I wrote dated 23 October 2015. So I've got a good memory. It's 9 years ago, or 9 years on. But that paper references the case Jenkins and Ellett of Queensland case, where the power of amendment stated to vary all or any of the trusts declared. And so when the matter came before the court, what was wanted to be amended was something that was in a schedule to be trusted. And because the power of amendment had said very just where hearing before, the court said, well, that does not extend to allow amendment of what was subsequently contained in the schedule to the trust. So, just beware. What's an Australian case, McCanty, which is also mentioned, went the other way. So why? Because the wording was sufficient to accommodate the amendment that was sought to be made of the part of the trustee that the amendment was held to extend. So other things that causes difficulty in trying to exercise these powers are just the broader rules of conflict of interest. In most family situations, you find that, John Smith example, John Smith's normally not the trustees, normally the sole one of the shareholders of a family trustee company is the director of that company, as sole or has become the sole age, is a appointor under the trustee, which is another controlling provision that's very common in those trustees, strictly trustees, and is a potential beneficiary. So between in each of those capacities has dutiful obligations under the law, and so for example, deciding to exercise in his own favour, raises questions. Well, do you have a conflict in acting as director? Do you have a conflict in acting as the appointer? Or you've got a conflict because now you're exercising your powers as director to benefit yourself as a beneficiary of the trust. So there's a thought process needed to deal with those sorts of conflict questions.
But John, so another beneficiary can't say, right, you got to rule yourself completely out, like it was some public situation, though.
No.
And that beneficiary is completely lost.
No, that's right. That's right.
Wants it, right?
Yeah, I think Daniel will talk to you a bit more about what sort of things you need to come and go with those circumstances. But no, I don't think you just totally disqualify it. That's your burden.
Yeah.
Mm. So I would think you've heard about, even if you're not professionals or dealing at that level, with what's called streaming provisions. At the end, Daniel will talk more about this, but I mean, if you go back to those early 70s and later deeds, I mean, there was no contemplation of capital gains tax. That wasn't introduced until with effect from 20th September 1985. So a lot of the trustees looked upon the income of the trust either being, as it's defined for trust law and accounting purposes, as not including capital gains, or those that were a bit more tax savvy might have referenced the what's in Section 95 of the Income Tax Assessment Act 1936, which talks about net income of the trust estate, which is a concept worked out tax act. And so when capital gains taxes come into the net income, capital gains come into the deemed income, they work into that definition, but not with interaction. With interaction in things like, well, if you 50% discount, general discount on the gain, then the 50% of the gain is not included in the assessable income. So what there's a need to work through that scenario in your trustee to have correct definitions of income, introduce streaming provisions that allow for the streaming of capital gains and so on. Too far. There's some collateral things that are interesting to be alert to too. With children who are now adults, I distinguish from most of these earlier discretionary trusts, being mobile, you can very easily find that there are foreign residents who are or who have children who become foreign residents, and that can be tricky with respect to trust holding residential property, or having acquired residential property within a 3-year period before someone becomes a possible beneficiary becomes a foreign resident, because there's a 7% stamp duty surcharge that can come to apply if that object of the trust has become a foreign resident in that 3-year period? Would you believe? And likewise, if the trust can acquire residential property, then the surcharge can apply, but if the person comes back, there could be a rebate. So, again, excluding and perhaps re-including people that are peripatetic like that is something that warrants thought. And for those that are looking at social security benefits with have a control of the trust switch with assets, the social security legislation will deem you to own, if you're an object, it will deem you to own the assets of the trust with perfect means death. So you need to be out of that trust before that test is going to be applied. So my next point is exercising the absolute and uncontrolled discretion that is given under the discretionary trustee. So I'll hand over to Dave. Thanks.
With that in mind, I might just talk about a recent case of OE's JJE nominees. It's a 2022 decision of the Victorian Supreme Court of Appeal, effectively a fight amongst siblings concerning the family discretionary trust with a value of $23 million. It dealt with a range of issues, but one of the reasons I wanted to chat to you about that is it had to do with a challenge by potential objects of the trust, which were two children, concerning the trustee's exercise of discretion to appoint income to beneficiaries. So I'll go through the fact matrix for that and then talk about some of the things that emerged from that decision. So before we get into that, one of the issues in that litigation involved a successful challenge by Paul and Deborah. They were children of parents that had set up the trust, and they were challenging the validity of certain amendments that had been made to the trust deed to change the description of the guardian and appointor, which, absent that challenge, would have seen those positions fall to their sibling Michael, who was the golden child, if you would. The position pre-amendment being that those roles would have ceased to exist on the death of their parents. That challenge was successful. The amendments in that regard went beyond the power of amendments. So another important reminder to read the deed. But the focus for me in talking to you about OEs is in the context of Paul and Deborah's challenge to the exercise of the trustee's discretion to appoint income to beneficiaries in various financial years that were under attack. In each of those relevant years, we saw no distributions to Paul or Deborah other than a capital distribution to Deborah in 2019, the residential unit that had long been her place of residence, despite their obvious need. With the whole of the income, which was substantial, the hundreds of thousands each year, being distributed to Michael and the parents in precise repeated percentages, with the exception of in 2019, we had the whole of the income going to the father, who was then quite elderly, had no perceptible needs for income, and where each of the parents and Michael were independently wealthy. The parents had substantial loan accounts with the trust, and the purpose for them was to loan back their distributions, increasing the value of their loan accounts, which sort of tends to go against need for provision. What always reminds us is that even where the trustee's power to distribute income is expressed as being absolute and uncontrolled, it's not without its bounds. The discretion still needs to be exercised in good faith and upon a real and genuine consideration. that real and genuine consideration issue involves the trustee properly informing itself of matters that are relevant to the exercise of that discretion. And clearly here in OE's, the needs and circumstances of Paul and Deborah, the children, the parents that had set up the trust, the primary beneficiaries, their needs were relevant to those matters. The trust was set up for their benefit. They were, and that of Michael, they were default beneficiaries as to income in equal shares in the absence of the trustee directly appointing that income or deciding to accumulate it. And none of those matters changed following any change or breakdown in the relationship as between the parents and child. Paul and Deborah had limited success in the Victorian Supreme Court at first instance. The trustee's discretion was found to have miscarried in the 2015 and 2016 years. In the 2018 year in relation to Deborah, on appeal, they succeeded in demonstrating the trustee's discretion had miscarried for additional years. Matters that were relevant to the court finding that the trustee hadn't properly informed himself to make a genuine decision with it. The trustee hadn't actually made any inquiries of Paul or Deborah as to their circumstances and need for provision. The trustee put an argument that it was imparted with information about those circumstances based on the fact that the parents were controlling that trustee company, and in the course of those relevant years there would have been conversations and meetings between the parent and children through which certain information about their circumstances might have been extracted, but in these circumstances the relationships were found to have been strained and there were long periods of estrangement. What also was relevant is these trustee resolutions distributing the income were formulaic. So we had the income going to the parents of Michael in precise and repeated percentages over many years, and the evidence just didn't disclose any obvious reason why the trustee would favour the parents and Michael in that way. And that same formula in each year strongly pointing to a lack of consideration as to competing beneficiary positions. I should add the financial circumstances of Deborah and Paul were considerably worse than that of Michael. And in particular, in relation to Deborah, she had significant medical issues that were compromising her ability to work and earn income. Obviously, the extent of the content of the obligation to properly inform oneself will vary according to the circumstances, and always reminds us that relevant to determining that is the size and the scale of the trust, the nature of the relationship that exists between the trustee and the beneficiaries, and the purpose of the discretion. Obviously, where there's a number of potential objects that could be very large, the steps that a trustee might need to take to properly inform themselves of matters that are relevant could be different. And indeed, you might suggest the requirement to undertake a detailed analysis of the identity and needs of each object in that circumstance just is workable. Nevertheless, there still needs to be an active discretion. That particular issue wasn't present in always, as the pool of primary and general beneficiaries was fairly limited. But what it does show is that apparent disregard of the circumstances of beneficiaries who are more closely aligned to the settlor's intentions in creating the trust could lead to a decision to appoint income being voidable. I think there's some practical tips to take away from OEs to minimise the prospect of a challenge by disgruntled beneficiaries. Trustees should fully inform themselves of the financial position and needs of primary beneficiaries at least. When exercising a discretion, as part of this, you might write to them to inquire about their respective situations, give genuine consideration to those responses, and then retain them as important trust documents, making sure decisions are dispassionate. When exercising these discretions and making decisions, they need to be in good faith and upon a real and genuine consideration, and avoiding these formulaic resolutions. Each resolution should be made genuinely and contemporaneously.
Andrew, are you taking questions?
Well, we can now, if you like.
Yeah, just briefly on this. So where does this go? Because in these circumstances, Paul and Deborah complained to the trustee they missed out 2 years. So the trustee says, okay, well, thanks, I just read your answers to my 20-page questionnaire about your circumstance. I now understand your circumstances. In genuine good faith, you're still not getting anything. That could happen. Would it ever be the case that a court might say, well, to a trustee, you've just not exercised good faith here, so I'm just going to overturn the resolutions you've passed over the last few years, which means that the income for those years will just go to the default beneficiaries. That's where it will land. Or would a court ever make some decision de novo and say, well, now this is what I think should happen? I can't see that happening. What would happen?
Look, there's sort of various outcomes that can arise in there. Ollie's case was interesting, and this is probably relevant to how you conduct these cases from a litigation perspective, but they succeeded in proving to the court that there'd been a breach of trust with the trustee making these decisions to appoint income. The decisions by the trustee were still held to be made within power, so there was no suggestion that there was a fraud on the power and they'd done these things in bad faith. What that ultimately meant is these trustee decisions were voidable, not void. And what the OEs didn't seek in those cases was relief to have those decisions set aside or for the trustee to pay equitable compensation to them. That issue emerged in first instance, and I think after the conclusion of the trial, they sought to amend their pleadings to claim that specific relief, and the court said no, and that finding wasn't challenged on appeal. So effectively, in monetary terms, it didn't get them anything.
Well, they won and lost.
They won and lost. Yeah, exactly right. With substantial cost. The other perverse issue that might arise is, let's assume that OE's case they did in fact seek that relief, and so a court found, look, decision made in breach of trust, I'm going to set aside these distributions. Where does that leave us? From the Commissioner's perspective, present entitlement crystallises as at 30 June in the relevant income year. We've then got the court subsequent to that dealing with those decisions, and from that there might be sort of separate consequences. That could see potentially the income going to default beneficiaries, assuming that the trustee has a provision dealing with that. Might result in trustee assessments, or it could leave those original recipients of that money having to disgorge themselves of the distribution, but still wear the tax liability. I was going to talk about some formalities for effective decision making. I'll just go through them very quickly, mainly from the perspective of distributing incomes. The golden rule is breach of trustee. You need to understand how decisions need to be made, when they need to be made. Your distribution resolutions need to be made by the earlier of 30 June in the relevant income year, or the date required under the trustee. So you need to check that. Where you've got a corporate trustee, in addition to the trustees, you're looking at your company constitution. You're making sure that decisions of the directors are being made in accordance with the company constitution and the Corporations Act. If decisions aren't being made in accordance with all those documents, the results can be catastrophic. You've got invalid decisions, then you've got potential income going to default beneficiaries where it's not intended that they might take, or we don't have those default provisions, trustee assessments, paying tax, the highest marginal tax rate, where the income includes capital gains. You're not then availing of the CGT discount or small business concessions. So the starting point before making any decisions as trustee, you need to have a full copy of the trust deed and any variations to it, and familiarise yourself with it. There's a few clauses in the deed you definitely want to pay attention to. So the first is, how is income defined under the trust deed? Most will include a specific definition of income, though older deeds might not, in which case income is determined according to trust law concepts. The income of the trust estate won't necessarily be the same as the net income for tax purposes. In fact, older trust deeds that don't include capital gains as income, if those gains aren't effectively streamed, beneficiaries can be required to pay tax on their share of that net capital gain without being entitled to the benefit of it. So ascertaining what the income is important. John touched on this, but looking at who are the beneficiaries that are eligible to receive distributions of income, capital. John touched on the spouse issue, but what about where the deed defines beneficiaries to include children? Does that include stepchildren or ex-nuptial children? What about people that might have previously been recognised as a beneficiary but now aren't eligible based on their circumstances? And the classic example, as John touched on, was someone that subsequently becomes a foreign resident if the trustee excludes them from being beneficiaries. Under the deed, what under the trust deed needs to be done to make a beneficiary presently entitled to a share of the trust income by the required time? Are there capital gains or dividends that's earned by the trust that need to be streamed to beneficiaries? There could be good reason to make a particular beneficiary specifically entitled to a capital gain. For example, if they've got their own capital losses that can be applied to offset the gain, or it might be relevant to accessing small business CGT concessions. Checking your vesting date, make sure it hasn't passed or is fast approaching. Once a trust vests, the beneficiary's interests in the trust are fixed and there won't be any discretion to appoint income or capital. You need to consider the tax consequences of making a distribution. Are there any restrictions that are effectively placed on making a distribution to a beneficiary from an income tax perspective? For example, is there a family trust election in force? Or is the amount and source of a distribution relevant to a beneficiary being a significant individual, which is then relevant to accessing the 15-year exemption, retirement exemption under the small business CGT concessions? When you're preparing and executing your resolution, some practical considerations, estimating the trust income derived for the particular income year. It won't ordinarily be possible to precisely determine of the trust for the relevant year. So the trustee might want to draft the resolution which makes beneficiaries entitled to a percentage share of the trust income, or if you're going to use specific dollar amounts, making sure that any remaining balance is then going to a specific beneficiary. I touched on earlier, when exercising the discretion, you've got a duty to properly inform yourself as to matters which are relevant to the exercise of the discretion. There's no standard form for resolutions, but it needs to be expressed clearly and unambiguously in accordance with the relevant distribution procedures set out in the deed. And typically it would specify the relevant clauses in the trust deed being relied upon. I did also want to touch on some corporate formalities where you've got a corporate trustee, so making sure any requirements for the directors in relation to making distributions are met. This includes under 251A of the Corporations Act, where proceedings and resolutions of directors need to be recorded in the company's minute book within 1 month. And something a bit more obscure, but check the company constitution to see whether it prescribes a minimum number of directors that need to be acting at all times. Some older constitutions do this. Don't just assume that so long as all the directors recorded in an ASIC search for the company sign the resolution, it will be effective. As John said, often these issues emerge after relevant income year has been and gone, rather than in confirmation of it. There's always the option to try and regularise that decision or have it declared not to be invalid. 1332 subsection 4 of the Corporations Act is a possibility, but it's timely and costly, and there's elements that need to be met to invoke that relief, which you might not easily do. Not all is necessarily lost if the board, once properly constituted, and despite the number of directors falling below that minimum, there are still sufficient directors to form any quorum prescribed in the Constitution, which might be different to the prescribed minimum number of directors. So in those circumstances, the resolution could be say that this avoid these arguments. So you're always thoroughly reviewing your trustee, your variations, and your constitutions to make sure everything's been done in the way that it's intended. Pass back to you, John.
And that's a real life example too, not theory. And it's interesting too, you're talking about the default beneficiaries, and in the trustees that we prepared initially, and I think we've habitually prepared that we have this great wide range of possible beneficiaries that go through family members. There's a bit more interest in bloodlines these days, but originally they went broadly through everyone you could think of in a family connection, and then said, well, if they've got a share in a company, well, that's included as well. I can even remember drafting a trustee that said John Howard was included as well, because he retrospectively amended the tax laws, which the chairman particularly disliked. So I think that he could be deemed to be entitled to something he wouldn't actually get. Anyway, now I think, and of course, that can tip into default beneficiaries, which is not ideal. So there's a bit more interest now in confining the classes of beneficiaries, so that one's not required to be making inquiries of mysterious people that have no connection with the trust. Look, I a little bit of time left. I thought I'd talk about intergenerational transfer, because that's that was the dot point, and it is something is growing interest. Of course, people are not finding it easy. Especially people want to think that families are functional, but the greater majority seem to be dysfunctional. So that presents the first challenge. The second challenge is that you kind of end up with a choice between one of two tyrannies. You can either have a tyranny of the majority and leave some people that are not in the majority out. So once you start with three siblings and you decide that two of them are honourable and one of them's not so honourable, that one that you've decided is not so honourable, then overall turned out to be the one that was honourable after all. It's at risk. Or if you make everything has to be unanimously agreed, well then there's the tyranny of the minority. Someone holding out and not agreeing to anything. So there have been a few strategies that been tried to address this issue. One strategy that we were very happy with for quite some time was what we call trust splitting. What we were able to do there was to appoint a new trustee controlled by a particular member of the family, and split off assets to be administered by that trustee, as opposed to ones that were continuing to be administered by the existing trust. And that appointment of new trustees still bearing the obligations of the trustee, to the original progenitor trust, seemed to work well. But the commissioner decided, after some time, after 2 years of success in this way, that capital gains tax would apply to a trust split, and so that really ceased to be great help. in intergenerational.
And what if the split's achieved right at the start when the trust is created? Is that okay then?
Oh, if that's a different strategy. If you've got one of the worth class,
Yes.
yeah, so that you've got that group of that group within the scope of one trustee rather than two.
Yes.
Entitled to benefits from these assets, etc. And another group is entitled to sibling family.
Yeah.
Is entitled to the other. That's fine. That's fine. They are buggers of things to deal with. I mean, firstly, the drafting of those class trusts proved to be, Herculean task, and then managing them. Just we get tripping over things all the time. Primarily because you've got one trust, you've still got one trustee, and you're trying to have them deal with this pool. But that's your pool, and then that's your pool. But hold on, your pool, and you're just string the darn thing together. Oh, that's a different idea. So that's a good idea. It's theory, a good idea. Because you've only got one trustee. In practice, it's harder. Putting in what we call distributor provisions was another strategy that people thought about, so that you can say, well, with respect to that asset, which might be a business, this particular individual is going to have the power to direct the trustee as to what happens with regard to the distribution of income, capital, and so on with others. The Commissioner has given some private rulings allowing that, but also made odious comments in seminars that those provisions have been watched very closely. So and there's been something of a shying away from them as well. A strategy that has been given a lot of vocal support, more so in the eastern states than I've found enthusiasm for here, is what, but I think there's merits, is what has been called a family company. The good thing about structuring a family company is that you can entrench things in the constitution of the company. Problem with trustees is that there's a doctrine called, which says, which is against fettering the discretion of the trustee. So some of these strategies where it suits to try and fetter the discretion of the trustee, you don't encounter if within the constitution of the family trustee company, an effective decision cannot be made about, say, in the class trust example, about that business, except if that particular individual you want to have control of that business makes approves the resolution of the trustee and give the power to disapprove, disqualify it as valid. So, so that strategy of empowering and disempowering decisions so that they can't be validly made except with the participation or approval of particular nominated individuals is where this family company style arrangement goes. And so so that might be might emerge. Another strategy that is more popular here is providing in the trustee that there's an obligation on the trustee to follow directions in the will for the deceased, of an individual who may later be deceased. So, and then for that person in their will to spell out what they want to happen in the discretionary trust. As I say, that's popular. That raises the question of, well, there's a fetter. The fetter may be entrenched in the provisions of the deed, because that's what the trustee is obliged by virtue of the provisions of the deed to do. I don't know, we have people who may have more experience in these matters than where this goes, but I think there's a bit of a moot point about just how effective that strategy is. So, so easy, but not so easy. I mean, you can always vest the trust, suffer the capital gains tax consequences of doing so, and then someone it's gone to the next generation. Vesting into another trust might mean that you pay some stamp duty as well as some capital gains tax, which is good. Vesting in individuals puts it back in the hazards of family law and asset protection, lack of asset protection, and all the other things that people originally thought trusts were very good at avoiding. Not that the laws worked out quite that way. Right, well, look, I think time's up because I said questions. We did have lost deeds, but I think we've lost that. So that's fine. So I can tell you in one tick, we people, there's lots of cases of people losing trustees. Rejoin trustee runs the risk of which in stamp duty, because if you were seen to be declaring trust of the property, that's a dutiable event. If you're confirming an existing trust, that may not be, but if you can't prove that it's an existing trust, that they still leave you up and running. And the strategy that we've seemed to have been able to navigate through those obstacles was for you to have a statutory declaration saying this is what I believe the terms of the trustee were, but you need evidence as to what is trustee. But by and large, any of these trusts that have had lost deeds, have had income distributions, have had income tax returns filed, they may even have had resolutions of trustees, there may be a fair bunch of collateral evidence that can help get over the lost deeds. All right, so do we have any questions? In fact, that's the time.
Stay on that. We have two on the basis of their breach of trust.
Yep.
Did they also see orders to have the trustees replaced or removed?
Yeah.
And so it's interesting because what would the or my experience has been when you're trying to have the trustee removed, neither side will agree on who the replacement is, because that's like the other's choice. So the court ends up appointing someone that they think is appropriate. That's usually someone in one of the big accounting firms who doesn't know anything about family, and then they end up distributing equally to everyone.
I think my memory is that so at first instance, the aggrieved children be sought to have existing trustee removed, and they failed and succeeded on appeal. The court said they had no doubt that in the interest of the beneficiaries as a whole, there needed to be someone who appointed. I can't remember whether they specifically appointed someone or just said that it needs to be someone independent.
It's a bit like when there's no binding death benefit for superannuation fund, but the trustee just triggers it. to the sort of first eligible person.
And it defeats the purpose of the trust. Yeah.
In the way in which they determine them to.
Yeah, I think you need to be careful when you're involved in litigation and you're going down that path. You need to think of the consequences, because if the court ends up just appointing someone who they think is appropriate, you might actually think you're succeeding, but then you're defeating the purpose of having the trust in the first place.
Daniel, back to that OE's case we talked about earlier. It sounds like an agreed beneficiary could send a note to the trustee saying, I don't think you're adequately considering my circumstances, you need to exercise good faith, etc. You don't do that, that's code language for give me money, then I'll consider getting into you for a claim for equitable compensation down the track.
Yeah.
Pretty good way to extort money out of the trustee.
Yeah, I mean, I think the key is not to be distracted by the decisions that trustees are making. What the court's concerned with is the manner in which the discretion is being exercised. So is it in good faith upon real and genuine consideration and for a proper purpose? And so what you had in OEs is over a vast number of years, you had no distributions whatsoever going to two people that were clearly in need for provision, and there not being any evidence as to the basis upon which the distributions that were actually being made were being made. So I think it was the combination of those things that led the court to infer that there was just a complete lack of disregard for the circumstances of the aggrieved children.
Daniel, what was always, I haven't read always, but was it more a case of there being evidence that there was no exercise of the discretion at all, as opposed to, because I'm just thinking about it in terms of the fundamental duty of a trustee is to exercise the discretion in good faith, and the main discretion usually, the daily and the yearly discretion is to distribute income. And they have to exercise that discretion in good faith,
Yep.
But there's no obligation on the trustee to disclose its reasons as to why they exercise their discretion in a particular way. Their fundamental duty is to just exercise the discretion.
Yeah.
And as litigation lawyers, we usually tell our trustee clients that they're best off not recording their reasons for exercising the discretion, because the moment they record that reason, then that is open to scrutiny and the court can take that.
It's a double-edged sword.
Yeah, so I'm thinking, because I would never tell a trustee to record its reasons, just exercise your discretion reasonably and in good faith, and you're allowed to exclude people for good reason, and one might be because
said that,
I think okay, so they did say that
the court said clearly, Deborah in particular had a strong claim for provision based on her need. That doesn't.
But that's a family provision claim. It's not a claim for breach of trust, for instance.
Well, it's a claim in the sense of receiving a distribution of income from the family trust. That doesn't mean that the trustee had to distribute income to her, but it was the fact that historically, consistently, there was no distribution. That is what pointed to the lack of consideration.
So I guess the strategic advice to a trustee is be careful about always excluding a particular beneficiary, and be careful about doing the same thing over and over again, because it almost makes it look as though you're just not even exercising your discretion.
Yeah, I mean, you always need to be exercising your discretion in good faith upon real and genuine consideration. And there's things that a trustee can easily do, conduct some level of investigation and make inquiries into the circumstances of the people that are closely aligned to the trust. There's easy things you can do to, demonstrate that you are exercising your discretion.
Yeah, sure. I just think it's still quite important that they not record the reasons for the exercise.
All right, so John, I've just got a question for you. The old trust splitting. A resettlement.
Well, we carefully argue quite some, yeah, quite some time, but eventually the commissioner decided it was.
The commissioner, the reason why he decided the capital gains was,
Well,
particularly was the resettlement.
Yeah, I mean, resettlement's not really word in the tax act, but
Yeah,
CGT meant he won.
Yeah.
To that. So, that's what put the kibosh on that. Although his ruling, his determination, sorry, does contemplate a form of split that you can do. But it's a bit of a Clayton's exercise because by the time you try and satisfy what the state allows, you're not quite sure whether you've really successfully split the trust or not. But you know, there is a way in which you can still try and work a trust split.
I had a quick one, personal one. You mentioned that a foreign resident might be susceptible to a surcharge for CGT. Wouldn't that be the case whether it was, if they inherited it, they're going to pay CGT on an investment property, for instance, irrespective of whether it's within a trust or outside a trust? Does it vary?
The surcharge I was talking about was 7% stamp
Yes,
duty.
yes.
But when you get into a foreign resident and discretionary trust, and for example, you mentioned capital gains. Well, you crystallise capital gain, and foreign residents won't get the benefit of the 50% discount.
But they won't either way. They won't within the trust or us.
Yeah.
So that doesn't really change.
The way in which the assessment of trust works
Yeah.
is do a calculation for the trust. And so you apply the 50% discount if it's not a foreign trust. And it could be a foreign trust if it's controlled by foreign people, but if it's not, you do that calculation, then whatever it is you pass to the beneficiary, like the share of capital invested, you gross up discount and then apply it if someone's eligible to apply. So the foreign resident that be eligible to apply. So it's not quite that it's only in both the trust and in the beneficiary. Yeah.
If there's only one beneficiary.
Yeah, what if it's only one beneficiary? Yes.
Because I prefer not to be sort of out the end of the gangplank all on my own. What are people doing with large beneficiary entitlement accounts, particularly for children or other tax advantaged family members, where there probably isn't a great desire to hand over a bunch of cash to settle the entitlement?
Yeah, well, it seemed like a great idea at the time to invest all this income in the children and not pay them. To some extent, you could try and apply what they were entitled to their own needs, which was probably okay paying university fees, but not so good trying to say you're paying for their next meal. So as you say, those accounts in many cases are built up. There's been a reluctance on Dad to go to the wealthy child and say, how about giving me a deed of release for that liability? And of course, as we know, Section 100A's been liable somewhat by the Commissioner to talk about reimbursement agreements and so on. So I think the answer to what you've asked is where any of those strategies are difficult, people probably got their head in the sand, waiting for an opportunity to assist the child if they can buy a house or do something where it looks like they're getting help, but actually they're just getting their own money. So, take your thank you.
Thank you.
Right.
Thank you.
You all.